now sitting at Boston within and for the Commonwealth. Draw near and give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. My name is Justice Peter Sachs. To my right is Justice Marguerite Grant. Joining us on Zoom as a result of some last-minute logistical issues is Justice Paul Hart-Smith. And we do apologize for those issues which caused us to have to delay the start of today's arguments, but we're here. We welcome you all to the court. We do, for the benefit of the litigants and the attorneys here today, we do have a group of summer associates, law students from a Boston law firm here just to observe the arguments. And the judges will be meeting with them afterwards just to answer general questions about the court and so forth, not to discuss particular cases, obviously. So if you've been to the appeals court before, or if you haven't, you will know that the arguments are 15 minutes per side. We don't have rebuttal in the appeals court, unlike in federal court. We have the lights on the podium. Green light is when you go, yellow light is when you have 90 seconds left, and red light means stop unless you're in the middle of an answer, or if you need to complete something, we'll allow you to do that. So we have read the briefs of the parties. We know what your arguments are, or we think we do. We have read the record, so we have a good idea of the facts. So I would urge everyone who's arguing today to get right to the heart of your argument. You don't need to give us a broad introduction to the nature of the case. And we will be interrupting you with questions, no doubt. So in our first case, we have only the appellee arguing. And that case, which I'll call now, is number 23P17, Walter J. Eno versus Nancy E. McGinn. And Ms. McGinn, you are the appellee. You are welcome to stand up and argue your case.
Okay.
And may I just add, if you see us up on the bench looking at iPads like this, we're not checking the baseball scores or anything like that. We have all of your case materials on the iPad, so we can look at your brief and the materials in the record from the lower court in real time, and we may be asking you questions based on what's in those documents. So that's what we're doing if we're not looking right at you. Thank you. Oh, and I should do a sound check. Judge Smith, can you hear us all?
Yes. Good morning.
Okay. And can the courtroom hear Judge Smith? Yeah, we're hearing that if you could speak more loudly, that would be appreciated.
Good morning. Can you hear me now?
Yes, we can, and we'll try to be as aware as we can of the need to listen carefully.
Thank you.
All right. So with that, finally, Ms. McGinn, why don't you begin your argument?
Okay. Good morning, everybody. I had an unfortunate accident, as you're well aware of, over 30 years ago. Within the past 7 years, I was just notified of a judgment against me, which I was unaware of, and I've been in disputes with the appellant, trying to make restitution.
Have you paid any restitution at all?
No, ma'am, because...
Not even a penny?
No, ma'am, because I was unaware of it, and then 7 years ago, he asked for one payment of $15,000, which I didn't have, and I sent a letter stating I did not have it, and then he increased the amount. He went from like $31,000, $37,000, he wanted one payment, and I was unable to do it, so I was instructed by my attorney to file for bankruptcy, and then they only wiped out the interest from the original court case that I was unaware of, and it still was like over $1 million. And
Well, they cut the judgment by 2/3 in the bankruptcy court, right?
I'm sorry?
The bankruptcy court judge cut 2/3 of the, I think it was originally $4 million, and they cut 2/3 of that off for you.
They cut out the interest over the 30-year period. That's what they told me. And so the original amount was like $1 million, and then he was awarded that because years ago you never had to be notified in person, like you do now, so I never received a notification, so he won that amount by default,
But didn't you file a counterclaim?
a counterclaim.
When he sued, you appeared and filed a counterclaim.
I did not appear. He said that someone else appeared to represent me, but I was never notified of the case. I had no knowledge of it. And then I've been trying to come to an agreement with him, restitution-wise, and he keeps changing the amount, and I'm a single person.
But you haven't even paid a penny.
No, he hasn't agreed to anything, and my attorney said that he has to write a contract and agree to an amount.
Isn't that what the bankruptcy court did when you filed for bankruptcy?
No, all they did was wipe out the interest. And then I still had to pay the remaining amount of $1 million, and then he is asking for an amount I can't afford. That's why I filed bankruptcy, because I don't have the funds to.
So when you filed for bankruptcy, what did you think was going to happen with respect to this debt?
My attorney told me, since the amount was above and beyond what I could financially afford, he said to file bankruptcy and it would be discharged. And unknown to my attorney and myself, the appellant was going to appeal it. So since he appealed it, then the judge, I had to go through a trial, and then the judge said he would wipe out the interest, and he knew that I was remorseful, and he wiped out the interest because I was unaware of the original court case. And that's what transpired with bankruptcy.
So as I understand the issue before us, it turns on this statute, Chapter 29, Section 31, in which the legislature said the comptroller may comply with administrative wage garnishments for bankruptcy orders. Why isn't that what Mr. Eno is asking us to do here?
Well, he originally got a letter in 2019 from the Attorney General stating that the Commonwealth of Massachusetts does not garnish only for child support, and they were not going to be involved, and they asked to have my university that I work for be removed off the docket or the case or whatever the proper terminology is. And I'm sorry, I'm trying to think. And so he did not agree with that, so he appealed. He kept trying to follow up on trying to garnish my wages because I'm unable to meet the financial requests of him.
Even a penny?
He won't agree to anything, ma'am. Your Honor, pardon me, everything he's asking for, I offered $300 a month. I offered what I could try and pay. And then my rent was just increased the month ago over $200. Financially, I'm a single person. I don't make a ton of money, and I've tried to resolve this.
Is it your position that as long as you work for the Commonwealth of Massachusetts, you're judgment-proof and he can't get his money?
I am unaware of what the Commonwealth's standard is. They sent him a letter, the Attorney General, stating that the Commonwealth does not do that. That's why I, for the past 7 years, have tried to come to an agreement with the appellant, and I've been unable to, because everything I offer, he refuses. And I've been trying to make restitution to put this behind us.
What have you done to try to make restitution?
I've offered him, I actually sent in my addendum to my brief a copy of the offers that I've made. I've made an offer to have an endowment in the person's name that was the original case with, and make payments in that way. There would be an endowment in that person's name, and the endowment goes on forever, and the scholarship would go to a student. And anything I offered, he's not accepting
When
it.
you say offer, you mean you put down words on paper saying this is what I would be willing to do if
Right,
you accept it. When you say offer, you don't mean here's some money.
No, my attorney told me that we have to come to an agreement, and contractually, he has to agree to it so that it's a formal end of the financial matter between us. That's what I was told. And so my attorney had me, between his attorney and my attorney in previous case, he would say, I want this amount of money, and then she would consult with me, and I would offer what I was able to financially afford. and then he would reject that offer, and then he would change the goalpost, so to speak, about the financial amount that he is requesting.
So as I understand it, at least part of what the plaintiff, Mr. Eno, was asking the Superior Court to do was a so-called trustee process, to order the comptroller to pay to him the wages that the comptroller would otherwise pay to you due to your position as an employee of Mass Maritime Academy.
As a wage garnishment?
Whether we use the technical term garnishment or not, we don't, is a separate question. But
Right.
In essence, the plaintiff was looking to have the comptroller pay to him the wages, or at least some part of the wages, that the comptroller otherwise would have caused a check to be cut for to you, your wages.
So, well, I had offered $300 a month, and then in a previous statement in the appeals court, he said he wanted $300 a month, and he was never willing to take a payment from me.
But the exact amounts aside,
Okay.
my question is what he wanted was to have your wages paid to him instead of to you. And since you're a state employee, the comptroller might be in a position to do that, since it's the comptroller that causes the checks to be cut to state employees every 2 weeks.
I believe he did contact the comptroller because my payroll office was notified, and I don't know what the comptroller decided to do. As I said, the law states that they weren't going to do that, and then I
Right.
think he was trying to appeal the process to see if they would approve it.
Right.
I believe.
That's my understanding as well,
Okay.
at least in broad terms. My question is this: I assume that the wages are paid. Do you have direct deposit?
Yes, sir, it's
Yeah.
required by the state. You're not allowed to do it any other way, sir.
Okay. So I assume that once the money is paid into your bank account, he could seek a so-called trustee process order against the bank, or issued to the bank, that says, bank, you have this money in your possession that belongs to Ms. McGinn, against whom we have a substantial judgment. Pay that money to us instead of Ms. McGinn.
Yes, that's correct, sir.
So he could seek, or even if he cannot obtain the money while it's in the comptroller's hands because of this state statute, it's possible that once the money is paid into your bank account, he could get the bank to at least ask the bank to pay it to him, or ask for an order that the bank pay it to him.
Yes, I've been told that by an attorney, sir. That's correct, yes.
Okay. And has he tried to do that yet?
No. No, we've been going back and forth trying to mediate between our attorneys, and I'm out of money. I don't have any more money. Most of my attorneys were doing it pro se for me, and that's why I'm here representing myself today, because...
Right. We appreciate that. Can't afford an attorney.
Yes, sir.
Do you have a position on whether this statute we've been referring to, General Laws, Chapter 29, Section 31, allows the comptroller to do what he's asking the comptroller to do? I'm taking it that you don't, but I'd be happy to hear if you did.
No,
We'd be happy to hear.
I don't. The only knowledge I had was the letter I got from the Attorney General that they had sent to him, and they had a representative come down in the original appeal trial, and that clerk was there, and he spoke on the Commonwealth's behalf. But you're correct, sir. I don't know the law behind the Commonwealth's procedure for deductions.
And what the Assistant Attorney General said at those hearings, or the different Assistant Attorneys General said, was that they, in their view, and in the comptroller's view, the statute did not allow the comptroller to comply.
Yes, sir.
Okay. All right.
Did you have any other questions? Or?
Let's see, any questions from Judge Smyth?
No.
No. All right.
All right.
All right. I think that's all the questions we have for you. Thank you for giving us your argument today. We understand it's difficult for a party without an attorney to come up here and present their position. You've done a very good job of it, so
All
we
right.
appreciate
Thank
that.
you very much.
Thank you. All right, our next case is number 22P1051, Department of Children and Families versus Father and Mother. This is an impounded case. And I would remind all parties and those in the courtroom that this, all of our oral arguments are available on YouTube and are being live streamed, as well as open to you, members of the public, in the courtroom. So because this is an impounded case, as I'm sure counsel are aware, we should not use any names or any information that would allow identification of the parties to the case, particularly the parents and any of the children involved. So with that, I believe we are starting with Ms. Openshaw?
Correct, Your Honor.
All right, and you will be taking 7.5 minutes, and Ms. Boulian will be taking 7.5 as well.
That's right.
Okay. All right, with that, why don't you give us your argument?
Good morning, members of the panel, and may it please the court, my name is Laura Openshaw, and I represent the appellant father who is present in the court today. This is an appeal about a termination of parental rights trial that was unfair from the start, and it was unfair in 2 ways. First, the father was denied due process of law when the trial court decided to hold the trial by Zoom over the father's objection, and then, without giving the father notice that he was expected to have more than 1,000 pages of trial exhibits immediately on hand during the trial court penalized him for his lack of access to those exhibits. And second, the trial court admitted several inflammatory out-of-court statements by child witnesses by relying on a flawed reading of Adoption of Luke, a reading that is incompatible with the nuanced approach to the role of child witnesses in care and protection trials seen elsewhere in the law, and that leads to harmful and unjust consequences for both parents and children.
Can I start by asking, how did the trial court judge penalize the father for not having access to the documents? As I understand it, he was testifying on direct in a circumstance where, while DCF might want to show him documents to refresh his memory, or else, as the judge said, read him portions of the documents if he couldn't see them, he didn't need the document. If they weren't able to refresh his memory, then they weren't able to refresh his memory. How was he penalized?
So he was, the father was called by DCF, and DCF was examining him as if on cross. There were a few examples that demonstrate that he was penalized by this. Generally, he was asked about the contents of several of these exhibits. For example, he was asked about the contents of a family action plan at transcript pages 144 and 145. He was asked about the contents of another family action plan at 146, whether he'd seen it. He was asked if he was aware of a 51A report from several years ago at 159, and asked about the contents of a 51A at 174. And he didn't have the exhibits in front of him. Couldn't say whether he, at least in one case, he said, I don't know, or I don't recall whether I've seen this action plan or not. And from very early on, from transcript page 146, the trial judge, when it was pointed out that the father didn't have this exhibit, he doesn't know which exhibit is being talked about, the judge responded that the parents had the ability to be in their homes with their exhibits, and they're not there.
Okay. But what's the prejudice? DCF was asking him about those documents for the purpose of refreshing his memory, if I understand correctly. If his memory was unable to be refreshed, DCF couldn't bring in the evidence that they wanted to in their case, in which the burden is on DCF to prove by clear and convincing evidence that the father was unfit. So if DCF is hindered in putting on its case, how does that prejudice the father?
Respectfully, I don't believe that the way the examination went was of a sort to refresh his recollection. He was being asked substantively whether he recalled the incidents, whether he was aware of the report in such a way that DCF later used to argue that he was not a credible witness, and that the fact that he didn't have the exhibit available to him to say, yes, I was aware of this report. Yes, I was aware of this action plan. For example, there was a point at which the father's participation in therapy in fact, very early in his examination, he was asked about his participation in therapy, and then he was shortly thereafter asked about whether it was in his action plan. Not having the action plan in front of him, he was in a position of saying, well, I don't know which action plan you're talking about. There have been so many.
What do we do with the fact that the father's counsel said to the judge at sidebar, I don't want anything to prejudice, and this is at transcript page 149. I did scan everything that was given to me and provided a copy to my client through the internet. I gave him a link to every single thing that wasn't redacted. And apparently the issue is that the father was not at home. He had these documents in his possession, but he was taking the call or engaging in the Zoom in a place where he did not have the access to the documents in his possession. Is that a violation of due process?
The violation of due process comes in the fact that the judge admitted a very voluminous amount of exhibits the day before the father was called as a witness. It is true, as Your Honor has said, that both the father's trial counsel and later the father acknowledged he had received electronically, I think he said, more than 600 pages of the exhibits. 600 pages is a lot to have either printed out or on a separate device. And in this case,
It doesn't help if you're working in a warehouse and trying to participate in the trial at the same time, which, as I understand, is what the father was doing. He was at work at the time of the trial.
that is what the evidence was. That is what he acknowledged. And this was a trial judge who, after was holding a trial by Zoom when the trial judge had the authority to proceed in person. This was a point in spring 2021 when the trial judge, both under the SJC's orders and the standing order from the juvenile court, had the authority and the discretion to hold the hearing in person. There was a motion filed a month before the trial for an in-person hearing, and that was renewed during the trial. And this was a case with, again, a very, very extensive trial record with a number of exhibits that the father's trial attorney pointed out.
But are you suggesting it was an abuse of discretion to hold the trial over Zoom rather than in person? I mean, certainly that was permissible as a general matter at this point in the pandemic, wasn't it? Or at that point in the pandemic?
The trial judge did at the point have the discretion. It was within the trial judge's discretion to hold it. Although we're not arguing that as the basis. We're proceeding on due process, not on an abuse of discretion. I would also argue that it was, particularly at the point where the trial judge was aware that there was a large record, that the father's trial attorney didn't have a number of exhibits herself, and that came up on the first day of trial repeatedly, where father's trial counsel.
Did she say at that point, Judge, we need a recess so I can have these documents?
She didn't seek a continuance, but she did move to strike those exhibits. And then at that point, she did also move for an in-person trial first before the exhibits were admitted, and then once the trial had begun and it had become clear.
Right. And the father was in Ohio at this point, if I'm not mistaken. So was he prejudiced by the denial of an in-person trial?
He was prejudiced by the in-person trial by what happened on the first day that he testified, that he didn't have access to those exhibits. The trial court held him from very early on, made it clear that she thought it was purposive, and that he was in a position where the trial court went on to hold that his character and his temperament were in two of the very first substantive conclusions of law, number 6 and 7, that there was a direct line between the trial judge finding that the trial was becoming an absolute waste of time, that he was a very frustrating witness, going on to the conclusions of law pertaining to his character and temperament.
Your time is up. I want to make sure that, or ask whether Judge Smyth has any questions.
No questions, thank you.
That's the remaining issues. I rest on my brief, and I would ask this court to vacate the decrees of termination of parental rights and remand the case before a new judge. Thank you.
Thank you. Ms. Boulian, am I pronouncing that correctly?
Bouillon, Your Honor.
Boulian, okay.
Like bouillon cubes. Good morning, members of the panel. May it please the court. My name is Laura Bouillon on behalf of Mother. Imagine a person walking into a criminal courtroom and they observe a judge offering to procure extrajudicial evidence for a prosecutor in a trial against a defendant. This person would reasonably question whether the defendant was receiving a fair trial. Due process requires that termination of parental rights trials be and appear to be fair. The requirement is violated where
Could I ask,
in a,
could I ask a question about whether this claim has been raised below? I wanted to honor the time limits for prior counsel, but can you address whether this due process and fairness claims were raised and whether we should be entertaining them for the first time on appeal?
Yes, Your Honor, I believe your question is with respect to whether this claim was raised below and elaborating on that. We would argue, Your Honor, that the trial counsel for Mother had difficulty observing at the time in a 12 inconsecutive day trial held completely virtually over the course of 3 months. It was difficult to see that all of the judge's comments and behavior and unfair conduct through the trial amounted to what we argued before, Your Honor, today, an apparent unfitness. We have the luxury of a bird's eye view in this case by being able to review the record in full, and review of the record in context would show that the trial judge's conduct and behavior was unfair and the trial was apparently unfair. I would argue, Your Honor, that this court, in adoption of Norbert, given the serious nature of the issues in our cases and the due process, and the fact that due process governs our proceedings, that this court reviewed the matter in that case, and I would ask that this court review it in this case as well.
But doesn't the length of the trial and the allegations you're making of unfairness, doesn't that weigh against your argument that trial counsel missed it?
We would argue no, Your Honor. The instances by the judge happened over each day of the trial. The trial was spanning over 3 months in consecutive days, held completely virtually. We would argue that the trial counsel, without the benefit of reviewing the judge's conduct in context, would not be able to see all of the conduct and comments of the judge and the disparate treatment of Mother and her counsel, as opposed to DCF and their counsel, may not have been as easily recognizable to a trial attorney on the ground conducting the trial. But upon review, and with this bird's eye view, I believe that we can see it here.
Many of the claims, though, in the heat of the moment or the trial were not even objected to. Would you agree?
I apologize, Your Honor. I'm having a little difficulty hearing you.
Many of the claims you've raised also as being unfair, violation of due process, there was not even an objection, never mind a general claim preserved, but there was no objection. Would you agree?
If I'm hearing you correctly, Your Honor, you're asking that the trial judge did not object to the instances of unfairness that I'm arguing took place. Is that correct?
Counsel did not object, correct.
Okay. So I would argue that in this court's dissent, Justice Hanlon's dissent in adoption of Norbert, did comment that, quote, failure to object to a judge's questions or to the manner in which he conducted the trial cannot carry the same implication of acquiescence as a failure to object to the questions of opposing counsel. I would ask this court to consider perhaps trial counsel was protecting Mother from the judge's conduct, as she may have been noticing it was increasing in severity. For example, when Mother would ask to speak with her attorney, the judge seemed upset and frustrated with her, and therefore Mother resorted to texting with her attorney. There was a threat of contempt against Mother. During her testimony where she was hyperventilating, the attorney did step in and did note that the court would provide Mother a break should this trial have been in person. And the judge did provide them with exact, quote unquote, exactly 3 minutes to speak with one another. A full and fair judge would have given Mother this break to compose herself instead of insinuating that Mother should continue giving this meaningful testimony under that hyperventilating and emotional state.
Why didn't the judge's comments in ruling on the motion for an in-person trial amount to essentially what the SJC said later in adoption of Patty that judges should do before conducting a Zoom hearing?
Is your question, Your Honor, why didn't,
You make an argument that the judge didn't give sufficient instructions about the fact that this was a Zoom hearing, as the SJC later outlined in adoption of Patty. But the judge said, if you need an opportunity to speak to your attorney, you have that opportunity. Just let me know and I'll take a break. And there was discussion of the fact that a Zoom hearing was better than an in-person trial at the time would be in some ways, because people didn't have to be behind masks, and the judge could interpret their facial expressions more. Why does what the judge did fall short of adoption of Patty?
So Your Honor is correct that the judge did make those comments, and Your Honor is correct that there were some guidance and procedures outlined at the beginning of this trial. However, this judge failed to follow through with those procedures. She does comment at the beginning of trial, should litigants want to speak with their attorneys, they should raise their hand and she would arrange to do so. She specifically referenced breakout rooms. Unfortunately, only one breakout room session was successfully administered. Alternatively,
Is there any request for a breakout room that wasn't dealt with either by creating such a room or by taking a break so that the counsel and party could communicate in some other way?
so there was, Your Honor, one instance where the breakout room was attempted to be opened to allow for a conversation. It was unable to be done by the court clerk, and therefore the mother and her attorney spoke by phone.
Okay, so did that result in any prejudice?
Taken in totality, Your Honor, the judge became frustrated with mother's request to ask for attorney, even though at the beginning of the trial she outlined how she was to request speaking with her attorney. Mother did so, and the judge seemed aggravated by mother, and mother therefore resorted to texting with her attorney largely through this proceeding. Should this trial have been held in person, that would not have been the
Well,
case.
isn't texting, though, better access than she might have in person? If she was in a courtroom speaking to counsel at counsel table, other people could overhear it, there'd be a chance they'd be misheard, it would distract the attorney from paying attention to things that the attorney might need to listen to in the courtroom. I mean, Zoom can't replicate an in-person trial precisely, but in some ways it might be better.
We would argue here, Your Honor, it was not better, that mother was prejudiced by not having meaningful communication with her attorney. As I mentioned, when she asked for it, the judge appeared annoyed by it. She was communicating with her attorney by text message, as opposed to the attorney asking the court for a break, or on natural court breaks, being able to go inside of a private room, a space in the courthouse, to speak with her and explain.
She was communicating with her attorney by text while she was testifying.
At times, Your Honor.
And that's not a part of an in-person trial, nor would it be permissible. Is that correct?
That is correct, Your Honor. I do believe in an in-person trial, the judge would have suspended the proceedings to allow mother to communicate with her attorney. There would
In the
not.
middle of her testimony, if a witness says, I don't know how to answer this question, I don't want to answer this question, a judge would call a recess and let them talk to their attorney?
No, Your Honor, but in the case where mother's testifying, she's upset, the judge is correcting her, saying, please don't provide these explanatory answers. She's getting frustrated with mother. Mother begins to hyperventilate because the court suggests a contempt against mother. And at that point, the attorney asks for a break because in an in-person courtroom, a fair judge would allow that break, maybe not to consult with counsel, of course, but to allow mother to compose herself to continue to provide meaningful testimony to the court. Here, yes, the judge did eventually allow that break, but she suggested the contempt. She was suggested that testimony continue, that DCF continue to question mother in her emotional state, and allowed mother exactly 3 minutes to compose herself and return to her testimony.
Let me check with Judge Smyth to see if he has any further questions.
Nothing further. Thank you, Justice Sachs.
All right, seeing no further questions, thank you for your argument. We'll hear from
Thank you.
Assistant AG Tretyakov for the Department of Children and Families. And just so I'm clear, you're taking 8.5 minutes for DCF, and Ms. Krasner for the children, you're taking 6.5 minutes. Is that correct? All right.
Your Honor, Mother would just rest on her brief for the remainder of her arguments.
Thank you.
Good morning, members of the panel. May it please the court. My name is Konstantin Tretyakov. I'm an Assistant Attorney General representing the Department of Children and Families. We're asking the court to affirm the judgments and decrees of the juvenile court where the trial court judges did not violate the biological parents' due process rights, correctly admitted the statements of children contained in DCF official documents under the adoption of Luke case, and where the judges' findings of parental unfitness are firmly grounded in clear and convincing evidence. The judge made 313 findings of fact in this case, only 6 of which are contested on appeal. The uncontested finding, even if the court limits its review to those, reflect years of domestic violence perpetrated by the father on the mother and the children, the mother's inability to protect herself and the children from the said domestic violence, failure to acknowledge, let alone address, the responsibility and the role that they have played in the serious trauma that they have inflicted upon the kids. The mother also has demonstrated the pattern of returning to the father, her abuser, after attempting to separate with him, and lack of the ability to provide for the children who had special needs and who have formed a strong bond with the now adoptive family.
May I ask you a question about the admission of child hearsay, which the father objects to in his appellate brief? I understand that there were motions in limine to strike or redact numerous, not redact, I should say strike, numerous portions of the 51A and 51B reports that were introduced as evidence. And some of those were allowed. Some of those requests by the father were denied on the basis that if the father wanted to examine or question the validity of the hearsay or the credibility of it, the father was free to call the declarant, in some cases the child, as a witness and cross-examine. The father now on appeal says that puts the father in an unfair position because if he has to call his own child to the witness stand to cross-examine that child about allegations against the father, that furthers the gulf and causes emotional distress to the child. Whereas if the father doesn't call the child to cross-examine him or her, then the father is left sort of defenseless against whatever the child may have said out of court and that appears in a DCF report. And that's a long wind-up to my question, which is, did the father make that argument at any point below that giving him the option of cross-examining the child was unfair and put him in a sort of on the horns of a dilemma?
I don't believe the father made that argument below, and more substantively, Your Honor, with respect to prejudice, the father cannot demonstrate any of that, even assuming, for the sake of argument, that the judge may have improperly admitted those statements, which he absolutely did not, because the adoption of Luke does not contain any exception to the children's statements. In fact, in that case, the SJC approvingly cited to this court case, care and protection of Leo, in which case this court specifically considered the statements made by a child about the sexual abuse perpetrated by that child's biological father to the investigator. And this court held that if the investigator and his sources are available to be called and cross-examined, then the rights of the father are preserved. And the SJC incorporated that reasoning into the care and protection of Luke. But here, the judge went even further in her very careful and measured approach how to take those statements, because if the court looks at the conclusions of law that the judge has made, she does not mention, those conclusions are not informed by any statements of the sexual abuse made by the children. So in that respect, Your Honor, the father repeatedly characterizes in his brief this as an expansion of Luke. This is not an expansion. Luke does not contain any exception for the children hearsay statements. And in that respect, the judge acknowledged the adoption of Luke when she made her, when she issued her findings of fact and conclusions of law.
A lot of the time when this issue comes up, the child's statements in the 51B report are somewhat further corroborated by a criminal conviction involved in I could not find anything in this record about any criminal convictions arising from these statements. Were there any, or what do we do with that?
Your Honor, after those statements were made, the DCF did make a discretionary referral to the District Attorney's Office regarding the statements and how the District Attorney would proceed with that. My understanding is that the District Attorney never pursued those cases in criminal court, and there is an indication in the record, and I'm specifically referring to page 1070 of the trial transcript. I'm referring to the consecutive pagination because it was provided to me in a very large transcript file, so it's page 1070. And I think there is an indication there that the DA's decision was partly at least based on the fact that the children were too young to testify in court. That's what I think was mentioned. But I don't think, Your Honor, that the decision by the District Attorney not to pursue this in criminal court bears any, quite frankly, relevance to this case, because proving guilt beyond a reasonable doubt before the jury of 6 or the jury of 12 is very different than establishing parental unfitness by clear and convincing evidence. It's a different standard of proof and entirely different procedure, civil versus criminal.
Can we get to the due process claims?
Yes, Your Honor.
First of all, whatever the requirements of the SJC's decision in adoption of Patty are, do you agree that we should apply them to this case, even though this case was tried before adoption of Patty was decided?
Yes, Your Honor. We are not contesting that the adoption of Patty is applicable to this case, and the key in the adoption of Patty was its affirmance in Commonwealth, in Velasquez-Diaz against Commonwealth, that due process is not a rigid rule. It is a flexible context. It is a flexible concept. And the key to understanding that concept is to provide parties with the opportunity to meaningfully participate in trial. And here, the trial judge, over the course of a lengthy 12-day virtual trial, went above and beyond to make sure that that was the case. Speaking, for example, of the father's right with respect to access to the exhibits, I'm referring to pages 149 and 310 of the trial transcript. Those exhibits have been provided to the father electronically by scanning them and providing him with a link to Google Drive by his counsel. After the father discharged his attorney, the judge entered a detailed order outlining how the father will access the exhibits, what redactions are going to be made with respect to the exhibits. So to the extent the father wanted to use those exhibits to cross-examine any witnesses, he absolutely had the access and the resources to do that. As far as the father's argument regarding his lack of access to the exhibits during his testimony, that argument is honestly quite hard to understand, because I believe Justice Grant pointed out there is no rule that a witness testifying at trial would have access to 700 pages of documents in front of them and would be able to refresh their recollection in the way they see fit with those documents. The rule is actually, quite the opposite, that the witness is supposed to testify from memory. So in that respect, with respect to father's rights, there was no violation. And with respect to mother, I see that my time is up, so just very briefly, unless the court has further questions. With respect to the claim of alleged bias, as an initial matter, none of that is before the court, because this has not been raised below, and mother had every opportunity over the course of 4 months to do that. And as far as the communication with her attorney is concerned, none of those rulings and opportunities to do that the mother is now contesting on appeal. None of that was objected to at trial. In fact, at one point, the mother's counsel expressed her gratitude and understanding to the judge when the judge allowed them to communicate even during the mother's testimony on the stand, which, as Justice Grant also pointed out, would be unheard of if the trial has been in person.
Okay.
Unless the court has further questions, the department will rest on its brief.
Any questions from Judge Smith?
No questions.
All right. Thank you.
Your Honor.
And we'll hear from Ms. Krasner.
May it please the court, I'm Sherry Krasner here on behalf of the 3 children. Just to set the stage and remind the court, my oldest client was not even 3 years old when he was removed. Not even 3 years old when he was removed. He's now 8 years old. The middle girl was 14 months old. She will be 7 years old in 1 month. And the youngest boy, removed just days after his birth in 2018, has just turned 5 years old. I understand that this court has an obligation to review the entire voluminous record of the case where the stakes are so high, but I ask that you act with as much speed as possible so that these 3 children can receive the permanency that they so richly deserve. Despite the challenges of the pandemic, this was a fair trial. That the judge ruled against father's request for an in-person trial because she saw these as delay tactics, particularly when she learned that father was in Ohio, didn't make her ruling biased. That she saw no merit in father's expectation that he, as a represented client, receive all of the 160-plus exhibits in his possession when she had so scrupulously reviewed with counsel about access to all the documents and had discussed with counsel the day before trial what they could do, what counsel could do if they didn't have documents. Did not make this virtual trial in any way evidence of bias, and certainly not a violation in the way that Patty was in terms of a due process violation. That the judge had to redirect mother or admonish her to listen to questions and not answer when there weren't any questions before her was not an example of judicial bias. It was just the judge moving the trial along, and something certainly well within her role in keeping proceedings moving. That the judge may have extended some courtesies to DCF was not bias, particularly where mother has not demonstrated in her brief how any of those courtesies affected the outcome of the trial. As DCF has argued, there were 313 findings here and 43 conclusions of law.
Well, the number of findings by itself doesn't really establish anything, does it?
Well, it established
It
that
may
she
establish
paid,
that she paid careful attention to the evidence.
certainly. And it's not the number. What matters is were any of those findings clearly erroneous?
Right.
And father does not argue that any of them were. He talks about there not being direct evidence.
Mother does argue that some of them were clearly erroneous.
She argues that they weren't fair. She never uses the
No,
term.
she explicitly says some of them were clearly erroneous. I think it's pages 41 through 44 of her brief, if I'm not mistaken.
There are 6 findings that she challenges, and again, 6, I know that the numbers aren't important, but 6, as in respect to 313, certainly suggests that the overwhelming number of findings have to be accepted by this court as true, and in the interest of time, I won't go through them, but I would refer you to Roman numeral 3A of my brief, in which I set out all those facts that this court needs to accept as true, and in Roman numeral 3B, how those facts in the aggregate all add up to clear and convincing evidence of parental unfitness.
So there was a lot of discussion in the findings the judge made about the parents' hostility to and inappropriate conduct toward DCF and DCF personnel. Does that in and of itself show unfitness? I mean, wouldn't any parent who is in a dispute with DCF over whether they can retain custody of their child feel hostility to and anger at DCF?
There's a difference, Your Honor, between feeling it and expressing it, and certainly the father in the ways that he expressed it, such that people had to obtain restraining orders and monitor, keep father from coming into the building. That was more than just I'm really angry that my children aren't in my custody. This was a father who was aggressively attacking the department, finding out people's addresses.
If that were part and parcel of the father's conduct towards the children or the mother or other individuals, then I could see the relevance. But if it is not, and if it's motivated by hostility to the department and wouldn't be a part of father's behavior if the department weren't in the picture to begin with, then how is it relevant?
Well, I would say the degree does make it relevant in this case, and certainly someone's temperament is relevant to someone's fitness, but also in this case, how father did act towards the children and the aggressive disciplinary tactics that he used, the running the planks and the demands that things be done, it's my way or the highway attitude that this father showed not only to his children but to mother's children, certainly I think is evidence of his temperament, of his inability to conduct himself in the way that we expect parents will conduct themselves, and therefore relevant to the determination of fitness. Certainly this father finding out where the pre-adoptive parents lived, and driving by the home, that all of that certainly is relevant to his conduct and a reasonable inference for the judge to determine that it was relevant.
The judge's findings also addressed mental health issues on the part of both parents. Did the judge ever draw a connection between those issues and any harm or abuse or neglect of the children?
Well, certainly she allowed the motion for father not to be able to visit with the children that
was sometime earlier in the case. I'm really talking about at trial. And that was prompted by abuse allegations, which the district attorney ultimately didn't pursue, and the father's visitation rights were restored. So that's not really an issue.
I'm sorry, could you repeat the question then?
Yeah, the question is, did the judge find any nexus between the mental health issues of either parent and abuse or neglect or threats to the welfare of any of the children?
I think she did make some findings. I don't think that was central to the determination. I think that the violence in the home, the violence that was perpetrated on mother and by father, and mother's comment that she was the victim and that the children observing this domestic violence, that they were not victims. I think that was very critical to the judge's ultimate finding. I think the parents' failure to engage in services, it was hard for the judge to make a determination about their mental health when they didn't engage in services, so there really wasn't evidence of what current...
So the principal factor here was the judge's findings regarding domestic violence?
I think that was a critical one. And
is there any other critical factor?
And lack of engagement in services.
But lack of engagement in services can't count against the parents unless the services are shown to be necessary. Would you agree with that?
Well, it becomes circular if it's a recommendation that they engage in services because there seems to be evidence of a mental health problem and you don't engage in services or don't even acknowledge that this might be something that could make me a better parent. I would suggest that that evidence says something about the parent's fitness to parent.
Okay. All right. Further questions? Any further questions from Judge Smith?
No.
All right. All right. Thank you very much.
Thank you. I rest on my brief.
Thanks to all of you for your arguments. We'll take it under advisement. And our final case of the day is number 22P983, Eric Madonna versus Mass Commission Against Discrimination. We'll just wait for the clock to be reset. Mr. Mantell, whenever you're ready.
Thank you. May it please the court, Kevin Powers and I represent Eric Madonna, the appellants in this case. We request remand of this case back to the MCAD for a determination as to whether the direct threat analysis applies and the proper application of that analysis, or in fact a determination that that analysis was violated here. There are two issues in this case. One, the MCAD acknowledges they did not apply the direct threat analysis. So if you determine that the direct threat analysis is applicable, that's it, we win. The next issue—
You win a remand?
We win a remand, yes, absolutely. And the next issue—
On a remand, hypothetically, would the MCAD have to or have the discretion to take additional evidence?
Say that again?
If there were a remand, could the MCAD decide to, or would it have an obligation to accept further evidence, either from your client or from the Fall River Police Department, his employer?
I think it could have discretion to request further information, especially since Gannon itself gives the burden on the employer to provide evidence that the risk posed by the employee is beyond any acceptable understanding of safety in that environment. So I think the MCAD could, in its discretion, open it up if the police department said, hey, we have this evidence.
Yeah. And the ultimate burden under Gannon is on the employee, if I understand correctly, to show that the employee is qualified to do the job without, in this case, creating the significant— I don't have the formula memorized, I'm sure you do— without creating the significant risk of substantial harm to the public safety.
You're right, but let me put it in different terms. The burden is on the employee to show qualification. Qualification is defined as the ability to do the job with or without reasonable accommodation. Now, the MCAD says that the issue of direct threat is irrelevant to reasonable accommodation, but reasonable accommodation is part and parcel of the definition of who is qualified, and so it is. Also,
You keep using the words direct threat. You're talking about whether or not your client poses a threat to the public? You're not talking about anyone threatening him at work?
there was no one threatening him at work.
Okay, I just didn't know where the words direct threat came from.
Right.
As some kind of a standard.
The direct threat standard comes from the ADA, which has a parallel protection.
And it's no longer the standard, if I understand correctly, but it was the standard at least before Gannon was decided. And so that was the standard that you said at the time of the MCAD hearing was applicable.
Right. That was the analog at the time. There's kind of three standards that you should consider. The MCAD had its own standard. The ADA had its standard. The MCAD standard was basically a copy of the ADA standard. And then Gannon came along and said, no, there's a different standard tweaking both of them. But as shorthand, we said we need the direct threat analysis applied here, and no one was confused by that. Everyone understood what that meant. In fact, the decision of the hearing officer and the full commission referred to direct threat cases. So they understood that. They just didn't apply the direct threat. So what they did is they applied a watered-down version precisely in the manner that the Superior Court case in Gannon applied it, and then the SJC says, no, that standard is not muscular enough. Okay, so we know that the standard that the MCAD applied was inappropriate, but their position is they didn't apply the standard at all. And we know the standard should apply because as Gannon explained on page 795, the direct threat analysis applies, quote, whereas here the city has limited the duties of a police officer because it considers him incapable of performing the essential functions of a police officer as a result of physical or mental limitations arising from the officer's handicap. Now, we know that the direct threat applies here because the limitations applied in Gannon, desk duty, taking away his weapon, and not allowing details, were the same limitations were applied here, except here, they also took away his police ID, cleaned out his locker and sent all his stuff home, prevented him from stepping on the location of the premises.
The hearing officer found two reasons for the denial of Mr. Madonna's request to do overtime and detail work. One of them was the chief's fears about threats that he might pose to public safety if he were in a position that had public contact. The other was that there was a written policy that those on light or restricted duty are not eligible for overtime or detail work. Is this a kind of a mixed motive case? What do we do with those two different motives on the part of the employer?
It's an interesting question. Both of those motives are wrong. So the first one, the concern about safety, is a violation of direct threat. The second one is an internal policy saying we're not going to give details to people on restrictive duties. But if your goal is to provide reasonable accommodation, those internal rules do not trump the obligation to provide reasonable accommodation under the statute. But even if you were to find that the rule was valid or somehow, okay, the fact that the hearing officer found that consideration of handicap was a motivating factor, that's enough to send it back because the hearing officer didn't identify what level of causation was in each. But we know there was a level of causation.
Do you have a position on, let's assume that the reliance on the policy were valid and non-discriminatory, then what happens if the hearing officer finds that the chief was motivated by both, as the hearing officer already has?
If the chief was, if it was a but-for motive, then there's a liability. We know under Lipschitz that there can be multiple but-for motives in discrimination law, and if that consideration was one of them, then there's liability.
So the MCAD argues at page 29 of its brief that you are, or Mr. Madonna is engaged in legal jujitsu, trying to transform a failure to accommodate claim into a claim of disparate treatment. How do you respond to that?
Okay. I have three responses to that. First, the direct threat applies to reasonable accommodation cases. And we know this because...
What do you mean it applies to reasonable accommodation cases?
Meaning, if you are giving a reasonable accommodation and that reasonable accommodation contains limits on you because of concern of safety relating to handicap, then the direct threat analysis applies. They're saying that just because it's placed in a reasonable accommodation mold, that direct threat is irrelevant. But that's not true. So, for example...
So, if I understand, you're saying that reasonable accommodation includes not only what changes to the job are made to allow the employee to perform it, but also whether the employee enjoys equal terms, conditions, and benefits of employment.
Exactly.
And in analyzing whether the employee was rightly denied some of those benefits, the question, that's where direct threat comes in?
Exactly. So there's two things. So first of all, in Gannon, it says, quote, in a qualified handicapped person case, however, the employer does not prevail simply because it indisputably acted in good faith. It can prevail only if the handicapped employee fails to prove by preponderance of the evidence that he or she was able to perform the essential functions of the job with reasonable accommodation. So the qualified handicapped person standard includes consideration of the reasonable handicap. Next, in a case I cited for you, an MCAD case, Hall versus Laidlaw. This is really good. I had the cite, but I didn't have this quote. It says, respondent can demonstrate that it could not provide the reasonable accommodation because it would pose a reasonable probability of substantial harm to the complainant or others. That's on page 38 of the Lexis version, and it says it again on page 51 of the Lexis version, meaning direct threat applies to the reasonable accommodation rubric. And then the full commission reviewed Hall versus Laidlaw, and it said the hearing officer engaged in the proper legal analysis. So their assertion now that direct threat is divorced from reasonable accommodation is contradicted by their own decisions and by the decision of Gannon itself, which says direct threat applies to the issue of qualification, which embraces whether the person could do the job with reasonable accommodation. So yes, limitations on reasonable accommodation are viewed the same as adverse actions. And we cite a wonderful case called McAndrews, which says when you have a limited reasonable accommodation, that's the other side of the same coin of adverse action. And in Hall, for example...
So a limit on the reasonable accommodation could constitute an adverse action.
It's
so
the same
they
thing.
offer him a position where he only works days, which is an accommodation to his sleep issues resulting from PTSD. But they say, the employer says, but that comes with ineligibility for overtime and detail work.
Right.
You're saying that's either a failure to accommodate or an adverse action.
Yes, it doesn't matter. And McAndrews says the character is the same for both. I mean, they're mirror images of each other.
May I ask why, once Gannon came out, I mean, I understand that the appeal from the hearing officer to the commission was briefed 2 years before Gannon came out. Mm-hmm. But once Gannon came out, why didn't Mr. Madonna file the equivalent of a 16L letter with the commission saying, hey, in case you don't know, even though you were a party commission, Gannon has been decided, it's relevant to this case, you should apply the standard. I understand that the regulations, the commission procedural regs, didn't explicitly provide for such a letter then as they do now, but neither did they prohibit it.
But also the full commission decision, we knew that the commission knew about the Gannon case. They filed an amicus brief in that case. We did too.
Right. They knew of the decision, but they might not know Mr. Madonna's position about how that decision should apply to his case.
He in the pre-hearing memo, in the appeal to the full commission, he was jumping up and down saying direct threat, okay? They're saying direct threat doesn't apply. So it does, but the full commission decision cites to Gannon. It's not like they were
sure they were. It's clear that the commission was aware of it. The question was the commission aware of the arguments you're making now about how Gannon should apply to Mr. Madonna's own case? And
yes, because the salient parts of Gannon were there and were argued in the appeals to the full commission, that the reasonable belief standard is not enough, that the subjective view of the employer is not enough, that they could have demanded an independent medical examination, but they didn't, that medical documentation is required to support a finding of direct threat. All that from Gannon was already there and already in the ADA regulation and things that were cited. So our argument is that the salient portions of our appeal were amply supplied, both in the 30A petition and the petition for the full commission, over pages. It wasn't one page, it was like 4 or 5 pages in each one. This was a major issue, so I think we've raised it. I just have go ahead.
yeah, quick question. The MCAD brief at page 29 says that the denial of detail opportunities was attendant to the agreed-upon reasonable accommodation. I'm not unsure if the commission is suggesting that Mr. Madonna agreed initially to the, okay, you're shaking your head.
No, after about 7 weeks, he inquired, I want to do details, and they said no. So he didn't realize that it was part. In fact, they acknowledged that it was a point of controversy as to whether they would do it or not until that moment. So no, he never agreed to reasonable accommodation with that limitation.
Okay. You were in the middle of making a point when I interrupted you, so.
Thank you. The other issue, the second issue, is the Superior Court in this case held that the MCAD held that there was no adverse action in this case. The MCAD doesn't even try to defend that argument. The MCAD, either in the full commission decision or for the hearing officer, neither of them asserted that what happened to Mr. Madonna was not an adverse action, would not rise to the level of an adverse action. So I think that's clearly erroneous.
One final question. You seek appellate fees in your brief, should you prevail. Assuming you prevailed in terms of getting a remand, do you know of any case in which fees are awarded for what you might term an interlocutory success that's short of a final success on the merits?
There are plenty of cases in the ERISA context which says that if there's a remand that's sufficient to award fees. We have to put in a request for fees in this brief, or else we waive the right for them even if we win later. So we have to put it in there.
All right. Thank you.
Thank you.
Oh, I'm sorry. I should ask if Judge Smith has further questions.
No, I don't. Thank you.
Thank you. All right. Thank you. And we'll hear from Ms. Milanazzo-Gaudet. Am I pronouncing that correctly?
Good morning. May it please the Court, Lynn Milanazzo-Gaudet for the Commonwealth of Massachusetts Commission Against Discrimination. This is a disability discrimination case. Based on the substantial evidence, credibility determinations, and the reasonable inferences drawn therefrom, the Fall River Police Department met its obligation under General Law, Chapter 151B, to accommodate Madonna's disability by creating a position that allowed Madonna to perform the essential functions of his job. This is and always has been a reasonable accommodation.
So do you agree that reasonable accommodation includes job modification, and I think I'm quoting from the MCAD guidelines here, that makes it possible for a handicapped individual to perform the essential functions of the position involved and to enjoy equal terms, conditions, and benefits of employment?
That is correct. That is what a reasonable accommodation would be.
Would the opportunity to do overtime and detail work for a police officer be one of the terms, conditions, and benefits of employment?
Yes, it could, Your Honor, but I would say it would be something which would have to be contextually analyzed. And in this case, when the hearing officer was considering the evidence that was before her, what she looked at is she looked at not only the accommodation that was provided, which was above and beyond which was required by law, but also through the evidence and the credibility determinations and the interactive dialogue that occurred, came to the conclusion that the accommodation was that of an evidence custodian, and with that accommodation also came the corresponding restriction on the overtime and detail, which was provided by the standard operating procedure.
So is are those two logically inextricably linked? That is, the daytime work that the evidence custodian position involved and the denial of detail and overtime work? Is there some connection between them that is beyond the MCAD's or our scrutiny because it just has to work that way?
Well, Your Honor, I'd say that nothing necessarily has to work that way, but I think that when the hearing officer was looking at the evidence, she looked at it as a whole. What is the accommodation that's being provided to Madonna in this case? The accommodation that he wanted to work days, that he wanted to work 9 to 5.
Yeah, but he also wanted to work overtime and details.
When that was raised, which was part of the original accommodation, part and parcel just as a big lump accommodation, when it was raised after the fact,
When you say it was part and parcel of the original accommodation, what are you referring to? Was he told when he was offered the evidence custodian position that he wouldn't be able to do detail and overtime work?
Well, Your Honor, there was no evidence in the record that shows that that was part of the communication as far as the accommodation was concerned.
You don't contend that he agreed to it?
I don't contend that he agreed to it, but I don't contend that it came up during the conversation.
Okay. All right.
That he was given a light-duty evidence custodian
Was he
position.
told that it was light duty at the time? Or was he just told it's going to be daytime?
I don't think the record reflects what was said as far as light duty or not light duty, but Mr. Madonna, in the record and when filling out his application for disability benefits, notes the fact that it was a light duty position. So he acknowledges that he knew it was a light duty position in that application process.
Later on, he says that, but there's no indication that he knew that or let alone accepted it at the time. He said, yes, I'd like to do this evidence custodian job that you're offering.
There is evidence that he said, yes, I'd like to do the evidence custodian, but there is no evidence that I'm taking this evidence custodian position in a light-duty role. However, once he found out, and it's clear that he did not know at the time, nor that it was discussed, but once he found out that there was a light-duty restriction, he could have brought it to the attention of the city in a way that I would like to engage in an interactive dialogue to see what we can do.
Right. And I take it from your brief, you're arguing that he essentially abandoned the interactive dialogue, interactive process of arriving at a reasonable accommodation, which is not just a one-time deal, but is an ongoing discussion between the employee with a disability and the employer to figure out what is a reasonable accommodation.
Exactly. And
did the hearing officer find that he had abandoned it?
The hearing officer made a number of findings of fact regarding the interactive dialogue. As a matter of fact, I believe there were 6 separate findings of fact that go to the fact that what went into making this accommodation possible for Mr. Madonna. The hearing officer makes no specific finding regarding interactive dialogue, but I think it's implicit in the reasonable accommodation analysis that was put forth by the hearing officer. Now,
well, the hearing officer didn't examine this case as if Mr. Madonna had abandoned the interactive process for a reasonable accommodation.
There was no explicit finding regarding that.
And the commission didn't either.
The full commission did not touch on the interactive dialogue, that's correct. However, again, the findings of fact do support the fact that the hearing officer did take into consideration evidence pertaining to that interactive dialogue.
Can we affirm the commission's decision on a ground that was not articulated by the commission itself?
I don't think it's necessary that the decision be affirmed on a ground that wasn't articulated. The findings of fact and conclusions of the law here support the commission's finding in total. Here we have a situation where Eric Madonna requested an accommodation, and there was discussion regarding what accommodation could be provided to him. He was given an accommodation that fully allowed him to perform the job of a police officer. As far as any type of...
But fully perform the job of a police officer includes ordinarily eligibility for detail and overtime work, doesn't it?
Well, as the hearing officer found, that was really a corresponding part of the job, given the facts of this case, and it was a corresponding restriction that went along with it, in that the standard operating procedure did not allow individuals on light duty or individuals on military leave or leaves of absence or anyone who was suspended from performing any type of detail work. So as far as that finding is concerned, I believe that the case could be sustained on that. Now, my brother goes into great detail on Gannon and the applicability of Gannon in this case. And Gannon is distinguishable on a number of points. Factually, Gannon is distinguishable because Gannon was a patrol officer who, after suffering repeated head injuries based on mixed martial arts, was relegated to a desk duty position because the city believed that he was incapable of performing the essential functions of the job because of health and safety to himself or others. In Madonna, we have an officer who was fully accommodated, an officer who this town believed was capable of performing the essential functions of the job.
You say in this case, he was fully accommodated?
I believe Mr. Madonna was fully accommodated.
Okay. Subject to his argument that he was denied some of the privileges and benefits of employment, the detail and overtime work.
Subject to that argument, however, again, something that could have been addressed had Mr. Madonna.
Yeah, and I guess the reason I was asking about whether the interactive process had been abandoned and whether the commission ever found that, which you said the commission did not, is related to my question about whether we could affirm the commission on a ground that it didn't articulate. So you're arguing that he abandoned the interactive process that might have led to some agreement about him doing detail or overtime work, if he'd only pursued it further instead of not reporting for work because of stress. But my question is, can we affirm where the commission itself did not articulate that rationale, and the commission is the expert agency that's supposed to be applying 151B in the first instance, can we affirm the commission on the ground that it didn't articulate abandonment?
Well, Your Honor, I think that the hearing officer's findings of fact and conclusions of law are sufficient to support a finding that disability discrimination did not occur in this case.
Okay.
Okay? That the hearing officer, in looking at the detailed work, did not find that it was an essential function of the job of a police officer. Detail work is voluntary in nature. It's not necessarily a required job function.
Right, but there are two parts. We started out with the MCAD guidelines defining reasonable accommodation as one that makes it possible for the individual to perform the essential functions of the job and to enjoy equal terms, conditions, and benefits of employment. So the fact that detail work and overtime work may not be essential doesn't mean that we exclude them from the reasonable accommodation analysis, does it?
It doesn't necessarily mean that we exclude it, but what we have to do is we have to go back and we have to look at the record. We have to consider the findings of the hearing officer, considering the conclusions of law. The findings are supported by substantial evidence. She, in examining the evidence, did not make any explicit finding that, yes, the detail work is an essential functions of the job. Quite the contrary. What the hearing officer found was that it was a corresponding job duty, that it was not necessarily essential. If it's not essential, it doesn't need to be accommodated. Here, the hearing officer found that based on the policy,
I don't know how you can get past Yee v. State Police by saying that, you know, overtime is just, or details are just this kind of extra thing that don't really count as a benefit of the job.
Well, Justice Grant, I think that when we look at Yee versus State Police, that the case that the SJC talks about the fact that everything is contextual, that what might be an adverse employment action to one may not be an adverse employment action to another. And it all depends upon the facts of the case. And here, the hearing officer looked at the case and determined that, you know, although, you know, Yee may be instructive, that in contextualizing it, the hearing officer did not determine it was an essential function of the job or something that needed to be accommodated, but a corresponding duty.
You mentioned adverse action, which prompts me to ask, the Superior Court affirmed on the ground not articulated by the Commission that there'd been no adverse employment action here. You don't appear to defend that particular rationale in your brief. I just wanted to confirm that you're not arguing that we should affirm on that basis.
The hearing officer did not address the issue directly of adverse employment action. However, you know, based on the evidence that came in, again, when we look at the detail was not an essential function. When we look at the issue with the gun, the hearing officer did not consider that necessarily an essential function, an adverse employment action, but instead, in looking at that, considered it, based on the facts of the case, an exigent event that occurred that needed to be addressed by the town for safety reasons for both Mr. Madonna and the town.
But the denial of the detail and overtime work, the Superior Court judge apparently said was not an adverse employment action. The commission, you're not arguing that that couldn't be considered an adverse employment action, or are you?
Again, I would cite back to Yee, where Yee stands for the proposition that you need to consider it in context. And the hearing officer
We always
in
consider
examination-
context, I hope. But the context here includes the commission's definition of reasonable accommodation as including enjoying equal terms, conditions, and benefits of employment. So I want to know whether are you advocating that we affirm on the basis of the rationale adopted by the Superior Court, that there was no adverse employment action here?
I believe that there was no adverse employment action, and that if we were to adopt that rationale, it would support the hearing officer's findings and conclusions in this case.
You've argued waiver in your brief. What do you say to to Mr. Madonna's argument that although he didn't know the precise test that would ultimately be adopted in Gannon, from the beginning of this case before the commission, he was arguing that the commission should not defer to the chief's judgment, even if it was in good faith, even if it had some evidentiary support about whether he was suitable or a safe person to be in contact with the public, but that the commission needed to make its own determination based on the direct threat standard and based on some articulable specific threat and a substantial level of risk. Is that enough to keep those issues at least in the case, even if Gannon had never been decided?
Well, Your Honor, first I would say that, renewing the commission's argument that 151B Section 6 does apply, that once the Gannon decision came down, that it would have been incumbent upon Madonna to supplement the brief and/or send in a letter to the commission to put them on notice that their argument regarding direct threat had shifted, and they were arguing that that Gannon should apply, which Gannon should not apply. It should not apply. Under a direct threat analysis, what we're looking at is an affirmative defense that was not raised by the Fall River Police Department in this case. The Fall River Police Department considered Mr. Madonna to be a qualified handicapped person. That was never challenged.
Right, but one of their two grounds for denying the overtime and detail work was that he posed some risk to public safety. And so, as I understand Mr. Madonna's argument, he argued, well, whatever risk there might be doesn't rise to the level of the direct threat, which there would have to be.
Well, Your Honor, I would say that to get to that place, what we would have to do is we would have to agree with Madonna's reading of the facts that there actually were two reasons why the chief, in fact, denied it.
The hearing officer found that. You don't have to agree with Mr. Madonna on that.
Well, my reading of the hearing officer's decision is that the hearing officer did not find that. What the hearing officer found was that the chief relied upon the standard operating procedure, and in the next paragraph, the hearing officer says, apart from that, there is no causation. What the hearing officer is doing at that point in time is she's bifurcating the reasoning, and there's no indication that the chief's personal belief in any way played into the fact that the solicitor on their own informed them that there was no need for the details because they were being precluded by the standard operating procedure. They were distinct.
Are officers who work a day shift not because they're on any kind of light duty or disability, like say the chief himself, are they eligible for overtime and details?
They could be eligible for overtime and detail, depending upon whether or not they're on active duty. If they are serving any type of suspension,
the question assumes active duty.
Yep. Thank you.
Let me just check with Judge Smith. See if there are any...
No further questions, thank you.
No questions, all right. Okay, thank you both very much for your arguments. We'll take it under advisement. That does conclude our sitting for today. We'll go in the back. We'll come out in